Good afternoon, everybody, and welcome back to the Wednesday webinar with us, the Property Law Alliance. And welcome to 2022. Well, I know it's the 19th, so Cilna and I were having a little bit of a debate about when is the appropriate time to stop wishing everybody compliments of the new year. And Cilna, we said that January. December is still fine, eh?
We think the 29th of December every year would be your cutoff. If you run into somebody the 30th or 31st, then you're just like, Happy New Year, but that's the same term. So essentially, you can carry Happy New Year the entire year. I think that's the decision, right, Chris?
Wow.
Happy New Year, Bruno.
That is the decision. Yeah. But it's so good to be back, and we really did miss the sessions that we have. We missed you, our viewers, and personally, I missed both Cilna and Bruno. So it's good to be back. It's good to be with all of you, and it's good to be back with our experts. Let's get straight into today's session. I know I usually ask how you guys are doing, but I'll say that for the end in terms of a conversation about what you guys have been up to and all of that. We've got some interesting questions, and a lot of them at that. So let's get straight into it. The first question says, can a purchaser, or for that matter, a tenant, cancel a deed of sale, or a tenant a lease agreement if they find out that there was a murder on the property, or somebody had died, or let's say a tenant gets mugged outside the property and says, now I'm going to cancel this because this area is dangerous. I didn't know that, or that somebody passed away in the property. Can the tenant, cancel early? And then can a tenant also refuse to pay an early termination penalty? Cilna?
Yes, so that's a very interesting question, Chris, and it's interesting because I've been receiving that question quite a few times lately. Not necessarily murder, but questions with regards to people passing away in a unit, and then the unit's getting sold or rented out, and the person taking occupation, either as the purchaser or as the tenant, finds out that somebody passed away in the premises, wanting to get out of either the sale or the lease agreement. Is this material? Is this something that can be done? Now, interestingly enough, I actually had this exact argument yesterday with another attorney, and I said, well, depending on whose behalf you're acting, I suppose you can spin the story slightly differently. But I think the actual real answer, that's the polite lawyer way of saying, sometimes the law is a little gray, and how you present the facts and what was disclosed prior to the conclusion of the transaction is much more relevant than just a pure rule. We have nothing in our law, nowhere in our law, that says the fact that somebody was passed away in a property, or the fact that a property was broken into, or somebody was murdered in the property, means that you can excuse yourself from any contract with regards to that property. Unfortunately, or fortunately, depending on which side of the deal you sit in, that's not something in our law. So what we do have is we're going to have to look at a lot of things. So starting point would be the actual contract. If the contract, the lease agreement, or the offer to purchase says anything about that, making it a material term. So there is a clause in one of these agreements stating that should it come to the purchaser or the tenant's attention that somebody was murdered or passed away in the property, they would be entitled to cancel the contract without penalties. Fantastic, then that's enforceable. But honestly, I can't see a clause like that ever appearing in any contract. However, if you market a property, so if it's marketed by an estate agent, you're going to have to look at the Estate Agency Affairs Board Code of Conduct. And now with the promulgation of the Property Practitioners Act coming into effect on the 1st of February, we need to look at those regulations. And the regulations require an estate agent to disclose anything that could be potentially material. Now, what would be material to you might not be material to me. For instance, for me to take occupation of a property where I know somebody passed away, it's sad, but I'm not superstitious or anything. I don't think superstitious is necessarily the right word, Bruno. You're going to have to help me out. But I don't have any religious rules or cultural rules or superstition or anything that would make that an issue for me. And I mean me, like actually Cilna, Petronella, Steyn, nobody else. I don't mind, but you might. Maybe it's a big deal for you. But how would the estate agent know? It's very similar to something that could be material for one person. For instance, when it rains, there is a lot of water running from the adjacent property onto your property. It doesn't cause massive chaos, and nobody's ever moaned about it, except you have a collection of very special arum lilies, and these floods happening into your garden, if it was just running over a lawn, wouldn't have caused a problem. But now it's causing a problem for you with your specific garden conditions. If something like that is material for you as a tenant or a purchaser, make sure that you make it known and include it in your application forms already in writing to say, you know what, Mr. Landlord, Mr. Seller, agent, please be aware of the fact that if there was somebody murdered in this place, or if there was a criminal activity in this premises, please let me know about it, disclose it, because it's material to me. Now it is material. Where for anybody else, it's not. Remember, guys, we live in the world, and please don't say South Africa and crime in South Africa. This is not the only country in the world with crime. The world has crime. And if there was a break-in in a property, that never, ever, ever allows a tenant to cancel the agreement. Because what would you do if you buy a property and you now have a burglary or something? And as sad as it is, unfortunately, it doesn't change the condition of the property. So the quick answer is no, it would not be material unless the tenant or the purchaser or prospective tenant or prospective purchaser makes it clear that these terms would be material. And for that exact reason, if it comes to a tenant's knowledge that somebody was murdered in the property, or somebody committed suicide or passed away in the property, and they did not say that these are material things for them in the lease agreement, unfortunately, the only thing they can do is a cancellation in terms of Section 14 of the Consumer Protection Act, and they will be liable for the full cancellation penalty in that regard.
Thanks, Cilna. Moving on to the next question, it says, I have recently purchased a sectional title unit from a well-known property developer. They had indicated to me that the registration would occur by a certain date. However, it appears as though registration has now not occurred or been delayed, rather. I suspect that the delay is due to the developer's action or inaction or lack of action. Is it possible to contest occupational rental in an instance where registration delays are caused by the developer? Bruno?
So registration hasn't taken place, so the viewer isn't owner of the property. So that's something that we need to be mindful of at this moment in time. I know that this wasn't an exact, this wasn't part of the question, but for the sake of everyone else, if the registration date has passed, or rather the promised registration date has passed and it still hasn't taken place, that is a breach of the agreement. So obviously it depends on the circumstances, why there was a delay, whose fault it was. There's a whole bunch of reasons why it wouldn't be a breach. But normally, if we go with what the viewer is saying and it was the developer's fault, this could very well be a breach of the agreement and could open up the question of canceling the agreement and actually walking away from the transaction altogether. The reason why that's also relevant to mention is, and Cilna, and I know for a fact Cilna will agree with me on this, so as lawyers, we don't just look at the exact facts, the problem, and just the outcome. Because sometimes to get a certain outcome, you need to understand what other outcomes exist, because those will those might be used to negotiate. So would a developer want you to step out to cancel the contract? No, they wouldn't. So if you go in there and say, look, I don't want to pay occupational rent, so I will cancel the contract unless you agree that I don't have to pay occupational rent anymore. So things like that in the law game it typically tend to help. So that's just something to bear in mind. If we're looking strictly speaking at the occupational rent, yes, there is room to argue that due to a delay in the registration of the property, that a person shouldn't be paying occupational rent. On the flip side of things, and this is where the complication starts arising, you are still enjoying occupation of the property. So it really becomes a question on, it's almost enrichment. Yes, the reality is you should be owner by now, but as owner, you would have enjoyed occupation anyway by virtue of your ownership. Now you're enjoying occupation, so almost as a tenant. So how can you refuse to pay rent where you are technically tenanting the property, and ultimately, even had you bought it, you'd probably have to be paying some sort of bond payment. You need to cover the property rates, whatever the developer is paying now, you would have to be paying anyway. And so that's why I wanted to mention that if a person uses the fact that you may be entitled to cancel the agreement as leverage to then negotiate with the developer to say the rent needs to go down, needs to cover bare minimum. I understand I'm still in occupation, so there are certain holding costs that you might be experiencing that we just kind of need to negate. But ultimately, you would probably have to pay something or other. But you could use the threat of cancellation to get it to a figure that's more suitable to you, or get them to rush.
Thanks, Bruno. The next question says, well, it's also just a discussion. It says, can we please discuss the municipality's responsibility in instances where an eviction might lead to homelessness? Can the court order that an eviction not be granted on the basis that the municipality has failed to find alternate accommodation for illegal occupants? And where does this leave the homeowner or owners in general? Cilna?
So we actually have quite a lot of case law on this, high court case law, like constitutional court case law. And actually now we miss our good friend Greg Vermaak on Blue Moonlight Properties and all the famous cases that we use where he was attorney of record. But Greg, so I'll answer this one on your behalf. But there is a municipality, there is an obligation, a constitutional obligation on the municipality to provide alternative accommodation. Catch is the person that is claiming to be homeless and destitute after an eviction will actually have to be homeless and destitute. I mean, we obviously do only evictions, so we see a lot of evictions. And I've seen like easy evictions, and we always call your rental evictions, your tenant that didn't pay rent, where you have to place on terms and cancel. We call those easy evictions because they are pretty easy. It's clear, straightforward, nothing funny law. So on an easy eviction like that, if you had a rental that you pay 25,000 Rand a month rental, we commence the eviction, the respondent files an answering affidavit, and they say, oh, but wait, I'm going to be left homeless and destitute. We all just like, no, in fact, you will not. If you were able to afford and qualify for a 25,000 Rand a month rental, unless something miraculously very strange happened in your life, the chances of you being left homeless and destitute is slim to none. But the court has an obligation in terms of the provisions of the Prevention of Illegal Evictions Act to do an inquiry into this. So what we see is the moment the court has concern about the respondents potentially being left homeless and destitute, the court will order that the municipality engage with the respondents, the illegal occupants, and then provide the court with a report to say what is happening in this. Now, if done correctly, you can actually end up with a dismissal of an eviction. And what I'm saying if done incorrectly is If, for instance, the municipality isn't added as a respondent to your eviction proceedings, the court has nothing to fall back on. So let's say you go to an attorney that doesn't do evictions for a living. They don't know that they need to add the respondent, the municipality as a potential respondent, and seek potential relief against the respondent. You could end up with a dismissal. That is true. But I'm not saying that you can get a dismissal based on law. That's basically a procedural dismissal, more than a true legal position, because legally, constitutionally, and in terms of by, the municipality has the obligation to provide alternative accommodation to a homeless and destitute person. And like I said, that was confirmed in multiple cases. So in a situation where you do an eviction, every single eviction, I always recommend to the attorneys I train, and obviously Bruno, I know you do this, we all do this, because every single eviction expert attorney will do this. You add the municipality as a respondent to your proceedings, and if you then have a problem, because you can't necessarily foresee this, say for instance, my example that I used on a 25,000 rand a month rental, say in the meantime, that income was derived from one of the spouses, they got divorced, the spouse that's now remaining in the property really does not have an income, bad things happen mid-divorce, somebody passed away, and really this person will now be left homeless and destitute. There is an obligation on the municipality to do an inquiry and provide alternative accommodation. I need to make it very clear, guys, when we talk about municipal alternative accommodation, we're not talking a nice RDP house. We are talking emergency alternative accommodation, which is very often tents. So those army sort of vibe tents, or like a communal living situation. We're not talking luxury living here at all. So if you're on the other side of the situation, and you won't actually be left homeless and destitute, but you hear the term alternative accommodation provided by the municipality, be aware of the fact that it's not something pleasant. It's really, it's basically just short of living on the street still. So that's important to be aware of. But as the homeowner, you will never, ever, ever be in a situation where you have to provide another property for anybody. Even if somebody's been in occupation, illegal occupation, for a period of longer than 6 months, then the Act does say that you might be responsible to provide alternative accommodation. But how the courts practically apply that is the court will simply allow the respondent extra time to remain in occupation of the property he is already in. So as a landlord, never ever be worried about, or a landowner, never be worried about a situation where the court will never order that you buy a flat for somebody or something like that. And as property owners, make sure you get to the right attorneys to do the evictions. Specialist attorneys won't accidentally be caught in a situation where you don't add the municipality. And you can request an order. Say, for instance, you can already see, here's a situation and somebody's going to be left homeless and destitute. We know exactly how to handle it. You bring an extra application to compel the municipality to provide a report, which saves a lot of time. If you sort of wait and hope for the best, it could be a 2-year game, but in real life, it wouldn't delay your eviction with much more than a month.
Thank you, Cilna. The next question says, I have a squatter living in my property, which is based in a complex. I'm in the process of obtaining an eviction order against the illegal occupant. Can the Homeowners Association hold me responsible for the occupant's use of water and electricity whilst he has been in illegal occupation? Surely this is criminal activity against the Homeowners Association and should be carried out by them. Bruno?
So did I get this question? All right. So
Yeah.
right. Remember, you are a member of the Homeowners Association. Pure and simple. Homeowners Association has no connection whatsoever to the tenants, short potential of them having filled out some register, so they've got access to, to their estate. they've got no connection, no contract, no obligation, nothing of the sort. Typically, well, okay, let me rephrase that though. There are certain occasions where a tenant, by virtue of driving through their estate, living within their estate, would accept certain rules, to which they bind themselves within their estate. So these would normally be it speeding limitations or noise restrictions, that sort of thing. So there are very general rules that tenants are made aware of. More often than not, they're actually compelled to be made aware of these in the lease agreement itself. So in the lease agreement, sorry, one moment. In the lease agreement, there would be a provision there for a display or an attachment where all these rules would actually be set out, and the tenant would bind themselves to these rules. So now you've got a set of rules, you've got the homeowner association and yourself as a landlord. Most of these rules would be enforceable by you as a landlord against the tenant. So payment of water and lights, you can't just put it on the tenant in the lease agreement and expect the homeowner association to go sue the tenant. That remains your responsibility. So membership fees, levies, anything that needs to be paid, you would have to pay it yourself. More often than not, you'd actually find that even the levying of penalties for speeding and noise would go against the owner's account. So even though, yes, there might be a right for the estate to actually reprimand or close close the swimming pool area down and ask the tenant and remove the tenant, the penalties would probably be for the owner's account. So just bear that in mind. You're responsible for the eviction. You're responsible for enforcing the rules of the HOA as against the tenant, and you are entitled to claim any damages that you've suffered due to this enforcement. So if you've been charged the penalty, you're allowed to sue for that. If water and lights, whatever the case is. Insofar as criminal behavior is concerned, I often don't spend a lot of time discussing criminal components, because in cases like this, we're not dealing with like criminal elements, we're dealing with civil law, right? And it starts getting complicated if we start getting academic on what is criminal and what isn't criminal. Where does theft lie? Things like this don't constitute theft. They're in occupation of the property. There was at some point or another some lawful reason for them to be in occupation, and you have civil remedies against them. There is no crime that technically covers this type of situation, that especially payment of water and lights and that sort of thing. There is no criminal offense that can actually be enforced or prosecuted.
Thank you, Bruno. The next question we have says, I bought a property and had to get 3 family members involved to show affordability. We drew up a contract with property attorneys that each person needs to contribute in order to get a share in the property. I have been paying the bond for the last 10 years. Another family member, pays the rates, and the remaining 2 family members have not contributed at all. Now, these 2 family members who have not contributed are demanding I pay them out for their shares in the property. The attorneys who drew up the contract state that this is a criminal matter and not a property case. How can these individuals, these family members, claim a share without having contributed anything toward the property? Cilna, how can we help this gentleman?
Sure. That is I do not see the criminal law element in this stutter. That's where that stutter came from.
Yeah.
Yeah, okay, I'm glad you say the same thing. Okay, so I think, Bruno, you so perfectly just said, to explain the difference between criminal and civil is an academic thing, and it's going to be super boring, but I can't see a crime here. So any crime must have specific elements. So the best I can think of that this attorney might think of would be fraud related something. But I don't see that every single element of every crime, and criminal lawyers don't sue me for this one. The last time I did anything on criminal law was probably at varsity, so I'm lying once in my articles as well. But every crime, unless there's now 3 exceptions that I'm not mentioning, must have an element of intent or severe negligence or something like that. And in this particular situation, the fact that the parties went to an attorney to draft up a contract means I can't see that anybody tried to do anything sneaky and intentionally or negligently attempting to harm another financially, obviously. So I can't see a criminal element, yeah, I definitely can't. So let's just move to the actual contract. Every question that we get asked in this particular one relates to that contract. And I think that's what makes it difficult to answer, because we can't see the contract. We don't know what the provisions were. So every contract that you draft, be it a offer to purchase, a joint venture agreement, a partnership agreement, whatever the case might be, you will have rights and obligations of the parties. And everything must be set out clearly. If you meet the essentialia, so the specific terms of a specific type of contract, for instance, a lease agreement, if you can see this is an agreement where property is being let to somebody, that the tenant will receive undisturbed and use and enjoyment of the premises for a temporary time period, and they will pay rent. It is a lease agreement, even if it's not called a lease agreement. And from that document, you will have both incidentalia and naturalia. That doesn't have to be written in the contract. So there are terms flowing from the nature of the contract. Now, because we haven't seen the contract, and I can't even guess, I'm guessing it's going to be either an offer to purchase that had a baby sort of with a joint venture type agreement, or a partnership agreement. It's going to be something like that. But without seeing the contract, I won't be able to determine what contract we're talking about. And for that reason, I won't be able to tell you what obligations each party had. Ideally, the fact that you say a property lawyer drafted this, it does tell me they would have thought of everything, and hopefully they did, and said party A must do this to receive this. Same story with party B, C, and D. And if the contract says you have to contribute X amount, you have to pay the rates and taxes, or you have to pay the interest on the bond, or you have to maybe not contribute money. Maybe you are the one that sourced the transaction and you had to find it. So you had to spend all the time and effort to secure the property. And then you are entitled to a 25% share in the property. Then you don't necessarily have to give money, and you would be entitled to your shareholding depending on how it was done. If it was done, for instance, in a company, what is your method that you use to value the shares in the company? What is the valuation of this property at this very moment? Did they buy and add more money to it? Is the value more or less? And can the parties sell to each other? And all of that will have to be handled in terms of the contract. So unfortunately, I'm giving a very wishy-washy answer, because my answer is I can't give you an answer unless I see that contract. So my advice in a situation like that is go back to the contract. Everything should be there. And if it is not, unfortunately, it's one of those severe litigation situations where it's going to come down to oral evidence. And unfortunately, we're talking a 3-4 year litigation, and extremely expensive. Bruno, am I just being blonde?
No, not at all. And I mean, we've touched on this type of question a couple of times when it comes to how important it is when buying properties jointly, that proper contracts be entered into. When a person refers to a JV, what that actually means. When people refer to stokvels or investment clubs, what that actually means. Because in the layperson's perception, some of these things are just, oh, well, it's simple. But it's not always simple. There's legal consequences. And sometimes you only figure these out when things go wrong. So in a case like this, where there was some kind of joint purchase of a property, yes, it comes down to what the contract says. Did the contract require that they perform? What does the contract say about what happens if they don't perform? How do you deal with them? Are they still entitled? Was the agreement ever cancelled by any chance or not cancelled? Can there be, this is somewhere along those lines. So it does get complicated, because I mean, Sure. I'm just thinking of some of the ramifications where if the contract's still in existence, no one canceled it, they just simply failed to perform, but no one did anything about it. The question now is, are they still entitled to their share simply by paying what their initial contribution should have been? And that's unfortunately where it starts getting to that area where it's important to have a contract, but it's also important to manage a contract. If you don't do the right things at the right time, you can't just go later and say, well, you know what, I should have canceled it. You should have canceled it, but did you cancel it? Because if you didn't, then unfortunately people still retain some of their rights even after a long period of time. And yes, it might be to your detriment, but unless you can prove that you actually suffered damages, yeah, it gets complicated.
Thanks, Bruno. Thanks, Cilna. I think we've dealt with a lot of questions today. I know that there were a few viewers who've asked some questions as well that we couldn't really get through to in this episode, but we definitely will deal with them in episodes to come. Hopefully next week as well, we'll be able to dedicate some time towards the questions that you asked. We have seen them, and we do thank you for asking those questions. But yeah, this has brought us to the end of today's webinar. I thank you again, Cilna and Bruno, for your time and for being with us. I thank the viewers who have asked the questions as well. And it's good to be back in 2022 with everybody. So from us, the Property Law Alliance, Cilna, I hope that you're well. I know I said I was going to give you guys some time to tell us how you guys are doing, but I'm rushing off to a meeting. I'm not going to even mince my words. So,
and we've had amazing questions, but I'm well, and we'll see you next week.
Thanks, Cilna. Bruno as well. It's good to see you. It's good to be back with you.
Good to see you.
I hope that you're well as well.